that we have going on here. Let's get started. I think that everybody's busy and everybody's dealing with the various issues that we've got facing that we're going to address today, at least a portion of which. First, let me introduce myself for the people who don't know me. My name's Nick Camiotti. I'm a principal at Bressler, Amory & Ross, and what we wanted to do here with our webinar series is to try to provide practical, relevant information in this ever-changing world and this new landscape. Obviously, with the mandates that are in place, we can't come and see people individually, so we're adjusting and we are trying to get in front of people digitally, and this is the first in what we hope to be a series of webinars which will address these primary issues. Today, obviously, a lot of businesses are facing various employment issues and dealing with the federal and state legislative developments. So we have a very distinguished panel here of members of our employment and our regulatory teams who are going to speak on these issues. I'll let first, we have Matthew Penfield from our Birmingham, Alabama office. Matt, if you'd just like to introduce yourself, that'd be great.
Sure. Hey, everybody. Matthew Penfield from down in Birmingham, Alabama. Glad to be here and look forward to answering hopefully some of your questions today.
Okay, and then next we have Emily Bordens in our New Jersey office. Can you introduce yourself, Emily? Emily, you're muted. Hold on.
Let's see if okay. I'm good. Okay. I am Emily Bordens. I'm from our Florham Park, New Jersey office, and I'm very pleased to be here today, and hopefully we can try to help you all work through some of these issues.
Okay, and next we have Cynthia Borelli, also from Florham Park, New Jersey. Cynthia, can you just introduce yourself?
Sure, I'm Cynthia, and I direct the firm's insurance practice group. I'm going to talk today broadly about federal and state stimulus efforts and regulatory developments, primarily in New York and New Jersey.
And lastly, we have Evan Yablonsky. Evan, you want to introduce yourself and talk about what you're going to speak on?
Thanks, Nick, and good afternoon, everybody. My name is Evan Yablonsky. I'm from our Florham Park office, and today I'm going to be discussing contractual issues that are going to arise in light of the pandemic we're all facing.
Okay, so just a few quick housekeeping things that I'll discuss before we get into the presentation, but we've received a handful of requests for written materials. At this point, we're not planning on circulating anything written due to the rapidly changing landscape that we have here. As things get more settled, we may do so. We are recording this and we'll make it available. In which manner, we are also still figuring out as well. We're working on the logistics there. For CLE credit, for all the lawyers who are watching, I'll be saying 2 codes. We have to do this for the webinar, so I'll be saying 2 codes that you'll need to input on your form that you'll be receiving via email. Please write them down and then include them on your form that you'll need to submit to get your CLE credit. I'll give you a hint. One will be after Matt speaks and one will be after Cynthia speaks. So pay attention at that time, and that's about it. So first, we're going to start with the employment issues that everybody's facing on a federal level and some of the emerging legislation here. And Matthew Penfield is going to address those issues. And Matthew, can you just give us an overview of what the primary federal laws that are coming out that employers are going to have to deal with?
Sure. Thanks, Nick. The primary law that we're going to talk about today is the new act that was just passed last week. It goes into effect on April the 2nd. That's the Families First Coronavirus Response Act. And there's 3 provisions in it that employers really need to attune to. The first is emergency paid sick leave. The second is Emergency Family and Medical Leave Expansion Act. And then the third part of that for employers, it's important, are the tax credits. After we talk about that, we're going to talk a little bit about how that interacts with some of the existing laws, the ADA, the request for leave under the ADA, and then how does that tie into the existing Family and Medical Leave Act. And then lastly, we're going to talk a little bit about what we need to just stay aware of with the Fair Labor Standards Act and payment to employees. But let me back up and start with the Families First Coronavirus Response Act. We're getting a lot of questions, and there's not a lot of guidance yet. In fact, I have a lot of employers who are monitoring the Department of Labor's website. There are a few questions and answers. There are a few posts about how it relates to some acts, but no detailed regulations yet. So it applies to employers with fewer than 500 employees. And in fact, Emily and I have been talking about, well, what does that mean? Since we have all kinds of acts that try to define what the number of employees are. The best answer right now came from the Q&A that was posted on the Department of Labor's website. And here's what it stated. You have fewer than 500 employees if, at the time the employee's leave is to be taken, you employ fewer than 500 full-time and part-time employees within the United States. That's about as broad as it gets. That includes people who are on leave. And so if you have fewer than 500 employees in the U.S., you need to consider that this act applies to you unless you meet one of the exemptions. So what do you have to provide? That's the question we're getting. You have to provide paid sick leave under this act if an employee is unable to work or telework, and then it gives 6 enumerated reasons. Are they under a federal, state, or local quarantine related to COVID-19? Do they have advice from a healthcare provider to self-quarantine themselves? Do they have symptoms of COVID-19 and they're seeking medical diagnosis? And then there's also some provisions that say you have to provide paid sick leave if they're caring for someone else who's under a quarantine order, or if you need to care for a child whose school or daycare is closed because of COVID-19. The key in all of these is the leave requested or needed because it is related to or based on or due to COVID-19. So what do you have to pay? Under this first act, the emergency paid sick leave, for full-time employees, you pay 80 hours of leave. And for part-time employees, it's hours equal to what that employee works over a 2-week period, what their average work is over a 2-week period. Now, here's one aspect of the Emergency Paid Sick Leave Act that you need to be aware of. It is available for immediate use when it becomes effective on April the 2nd, regardless of how long the employee has been employed. It is available immediately. So employees need to get to use the sick time. You can't require them to use any other paid leave that they have or that you may offer. They're entitled to this sick leave first. We are expecting guidance from the Department of Labor on what notice has to be posted. Like most of our federal laws relating to employment, you have to post those in conspicuous places at the place of employment. They've told us they're going to release that today, March the 25th. I checked the website just before we started, and it's still not there. We'll send something out when it is posted, but you need to follow up and make sure you're watching for that. So important details on the amount of sick leave that has to be paid. Those are written into the act, and we hope to get some guidance from the Department of Labor next week when they offer, hopefully, more detailed regulations. And we're not going to get into all of the details about the amount, but I do want you to know that that amount is capped. There's a per day cap, and there's an aggregate cap for each employee, and it's dependent on the reason for the leave. There's one cap depending on if you're taking leave for yourself based on your own quarantine or self-quarantine order because of your own illness. And there's a different cap if the reason you are seeking the leave is to care for another person or a child. If you have questions about compensation, computation of that cap, we ask that you just reach out to us after the seminar today, and we'll hopefully be able to answer those. One question we're getting a lot about is anybody exempt from this? And the short answer is yes. The longer answer is we're waiting for a little bit more explanation as to who. The Department of Labor can exclude healthcare providers and emergency responders and small businesses, those with fewer than 50 employees, if following the act would jeopardize the business. I know that many employers have reached out through their trade groups and organizations asking the Department of Labor to define and give some clarity as to what that means, jeopardizing your business, and we hope to get some of that as soon as possible. Nick, that's the first part of the Act. The second part is an amendment to the Family and Medical Leave Act. It's called the Emergency Family and Medical Leave Expansion Act. And what that means is if you invoke that, your first 2 weeks of that are unpaid leave, which really doesn't matter quite as much because you're getting the 80 hours of paid leave under the first provision. But then it actually makes a change to the Family and Medical Leave Act, and that's going to be in place for the remainder of this calendar year. It adds that a qualifying need related to a public health emergency will give you the 12 weeks of leave. And the qualifying need means that the employee is unable to work or to telework because you need to care for a son or a daughter under 18 if their school or their child care is closed due to COVID-19 emergency declared by federal, state, or local authority. So the first 10 days are unpaid. The remaining 10 weeks are paid leave. And again, in the Act, there are calculations of the amount of pay, and there's a cap, both a per day cap and an in the aggregate cap. The third piece of the Act that you need to be aware of is that there is some relief for employers, and those are the tax credits. The details about the credits are in the Act, but the best explanation was in the news release that was issued by the Internal Revenue Service and the Treasury Department and the Department of Health and Human Services. And it simply says this: employers will receive 100% reimbursement for paid leave pursuant to the Act. It states that health insurance costs are also going to be included in that credit, and that's important, and that the government's goal is to make sure employers will face no payroll tax liability. The IRS stated that it's going to release guidance next week to allow eligible employers to actually retain an amount of payroll taxes equal to the amount of the qualifying sick and child care leave paid, so that you don't have to pay it to the government and then seek it back later this year. So you're going to be able to retain federal income tax, the employee share of Social Security and Medicare, and the employer share. There are numerous examples of that in the news release, but the guidance to you next week should provide more details.
So Matt, sorry about back there. How does the new law interplay with other forms of leave?
Yeah, and that's a great question. Before, I actually just noticed before we came on, before I get to that, there was a field bulletin issued I want to mention on this, the provisions of the new Act. It instructs some regional and district directors there's going to be a temporary non-enforcement period. So that doesn't mean that you can't comply, that you don't need to offer the leave, but it does mean that the Department of Labor is not going to bring enforcement actions for violations that occur through April the 17th. As long as you have good faith efforts to comply. So I wanted just to remind everyone listening that a best practice is to document your good faith efforts to comply in case you need it at a later date. Nick, getting what you asked, how does it interplay with other forms of leave? Well, what about employees who are already out on leave? The new Paid Sick Leave Act applies only when the leave is caused by or related to or due to COVID-19. So that means employees who may already be out on leave that's not related to COVID-19, then this paid sick leave is not triggered. It doesn't kick in yet. However, you need to be aware of and monitor those periods of leave. you need to watch them and be aware when they end, because it's very possible that you could have employees who are out on some other form of leave, and when those periods end, they may be eligible for this new paid leave that's now in effect, and you need to be ready to respond to it at that time. It's all very fluid right now, and we're hoping the government provides some guidance on regulations that may answer some of those questions. Well, the two main areas we're trying to figure out how it interplays with the best, though, are the ADA and the FMLA. Now, how does it impact requests for leave under the Americans with Disabilities Act? Most posts that I have seen and articles I've read, and we agree that we're in agreement that a request for leave to avoid getting sick does not automatically mean that that is a reasonable accommodation. However, it's a case-by-case basis. We always tell our clients that when you're making determinations of leave under the ADA, you have to look at each specific case and each specific request. And so if an employee brings a request for an accommodation, the facts of that case will need to be evaluated at that time. So what about employees who are already out on Family Medical Leave Act? Well, with the exception of the emergency family medical leave related to caring for a son or daughter under 18, if the school is closed, the FMLA provisions still apply. That means for those employees who are out on what we'll call the regular FMLA, they still have to have been working for 12 months. They still will have had to meet the hours, 1,250 hours, and the number of employees at a specific work location. There is a question and answer that was posted on the Department of Labor's website that I think is helpful. There's a question and answer that relates specifically to COVID-19 and the Family and Medical Leave Act. And it's worthwhile to take a look at that and read it. It does ask the question, you know, in general, can someone get family and medical leave for the flu? Well, the answer is it depends. It all depends on whether it's a serious health condition. It depends on how serious. It depends on if complications arise. So employers should not assume one way or the other, but follow what you can do to request information from the employee, to request information from medical providers when that's allowed, and make that determination on a case-by-case basis.
So Matt, with respect, Matthew, excuse me.
Yeah.
With respect to payment of workers, what can employers do?
That's a great question. I know our employers, our clients are really struggling with how best to keep themselves afloat during this time. They've asked, can we cut hours for our hourly workers? And it's important to remember that even in this pandemic, the FLSA, the Fair Labor Standards Act, it still applies. So that means what you have to do if someone is a non-exempt hourly employee, you still have to pay them for hours actually worked. If there's a need to cut back on hours, you can do that for those hourly non-exempt employees, but for every hour they work, you need to pay them. We fielded a lot of questions on that. So you can cut those hours, but you also need to remember and look at if you're part of a collective bargaining agreement, if you're in a union setting, or if you have other agreements with employees, you need to remember to pull those out. You need to take a look and make sure you're not doing something that would give rise to some other claim under those agreements. What about cutting salaries for those employees that are exempt under the Fair Labor Standards Act? The general rule is exempt salaried employees must generally receive their full pay in any week in which they perform work. And so you need to make sure that you're doing everything you can to not jeopardize that exemption. The weekly salary should never drop below the mandated federal amount, $684 a week. And you need to do what you can do to protect your business, but be careful not to take actions that could later be interpreted as changing or misclassifying employees from exempt to non-exempt.
Okay. There's some questions that we received in the chat, but I'm having problems seeing it. Evan, are you able to see it?
Yeah, there's certainly some questions coming across about if an employee goes out on COVID-19 leave on Monday the 30th, will they then be able to start collecting against the 10 days as of April 1st, Matt? Would this be deemed a pre-existing condition? Is there actual guidance on this and how it would be handled?
Yeah, that's a great question, and one that unfortunately we don't have a clear answer to right now. In fact, we have seen many trade organizations and employers who have written specifically to the Department of Labor and asked that exact same question. You know, what happens if employees are terminated prior to April the 2nd? What happens if someone goes out on leave for COVID-19 prior to the date that April the 2nd kicks in? We are waiting. We don't have a clear answer for that. What we would say is, you know, watch our alerts, watch what's posted on the Department of Labor's website right now. The act is not retroactive. So we're pretty sure that the answer from the Department of Labor is not going to be you have to start paying them this paid leave prior to April the 2nd. It's more likely that what we're going to see is if someone goes out on COVID-19 reasons prior to April the 2nd, then that paid leave would start on that date, but not prior.
Agreed.
Thanks, Nick.
Thanks, Matthew. Okay, so for the CLE credit, the first code is going to be social, SOCIAL. And next, we're going to turn it over to Emily, who's going to talk about some of the state-specific legislation that's come out recently.
Okay, great. So I'm going to kind of pick up where Matthew kind of left off. Essentially, I'm going to be talking about what happens if you have to close your office, okay? What happens if you furlough? What happens if you have to temporarily lay off your employees? So I'm going to kind of start with New Jersey's Executive Order 107, okay? So that's the stay-at-home order that is in New Jersey right now. And there are several other states, California, Illinois, New York, and several municipalities that are all kind of similarly enacting these kinds of orders. And I'm not going to get into essential or not essential, but for the purposes of what we're going to talk about, if you end up having to close because of the executive order, some companies are also just for economic reasons, they also have to close. So what happens if you have to furlough or temporarily lay off? We've been getting a lot of questions about this, and there is a difference, although it's generally the same concept. So a furlough essentially means it's a temporary layoff of work. And what happens is the employee is going to stay on your payroll like they're on an unpaid leave, essentially. And a furlough can also mean a reduction in hours. So kind of picking up off of what Matthew was talking about with FLSA issues, if you do a reduction in hours type of a furlough situation, non-exempt employees, like Matthew said, is pretty easy. You pay them for the hours they actually work. If you have exempt employees that have to be put on a furlough, that's a much more complicated issue. And you need to make sure that you don't violate the salary basis test. And so we've been getting a lot of questions about how you deal with pay for exempt issues on a reduced schedule like that. So if you have specific questions, we'd be happy to kind of work through those issues with you. But essentially, you would have to, you are allowed to prospectively reduce the salary based on the reduction of hours, but it has to have a good faith, reasonable basis so that you're not trying to evade the Fair Labor Standards Act. So we would have to specifically work through that with you. And just another issue with an exempt employee who's on a furlough, they cannot do any work. And the issue that happens with our remote lifestyle right now is that you might get an exempt employee who has a phone. they may still have access to your remote file system. If they do any work for you, they might be entitled to compensation. So if you put someone on a furlough, they're still going to be an active employee, but they'll be on an unpaid leave of absence. So you just want to make sure that you're aware of those issues. I also want to talk briefly about a temporary layoff. A temporary layoff is basically the same thing, but you're going to be separating them from your payroll. And a temporary layoff right now under New Jersey unemployment is 8 weeks. I believe under New York unemployment it's 4. But I think essentially for our purposes right now, you have to believe that the legislative landscape is rapidly changing. So I expect that they may be expanding that statutory time period for what qualifies as temporary layoff. Now, in both cases, a furlough and a layoff, the employee is going to be eligible for unemployment. Now, you almost have to have a crystal ball when it comes to unemployment because it's so complicated, the formulas, eligibility. So I hesitate to ever tell any of your employees that you're guaranteed to get unemployment. My recommendation is to say, okay, we're doing this furlough, we're going to roll it out. Right now we expect it to be 6 weeks or 8 weeks or 4 weeks or whatever you think it's going to be. Give your employees information on how to file the unemployment claims. And I'm going to be talking about unemployment in a few minutes, so I don't want to jump ahead too far. But essentially, you're going to try to give your employees the tools that they need so that they can have some kind of salary continuation during the temporary period. So the next question we get, and Cynthia and I were talking about this, we've all been kind of talking about this. What happens to the group health insurance? If someone's on a furlough, if someone's on temporary unemployment, does that mean that we have to take them off the insurance, that we can keep them on the insurance? And essentially, I'd rather focus the attention on COBRA and what the triggering events are. And for the purposes of our conversation right now, the applicable triggering events would be a termination of the employment or reduction of the hours of work, causing a loss of coverage. Now, Cynthia and I were talking about this before, and essentially what she was telling me was that large commercial groups are often exempt from a reduction in hours for non-hourly wage employees who are on furlough for brief periods of time. So our advice essentially is, if you have an issue or a question about whether or not you can put someone on COBRA or whether a COBRA notice is required, our advice really has been to check with your carrier, find out what your plan says, see if there's going to be, if they're going to relax the eligibility requirements. And again, I don't want to step on Cynthia's toes because she really is the expert in this area. But really what we've been trying to encourage our clients to do is check with the carrier, look at the plan documents, see what it says, and then you can make a decision about whether or not you can carry those employees on your group health plan temporarily while they're on a furlough. So now what I want to do is I want to talk about, again, going back to how is this furlough or temporary layoff going to be paid? And everyone is asking me about New Jersey Earned Sick Leave Act, okay? What we've been telling our clients is that, yes, it applies, okay? Right now, there is a bill, a Senate Bill 2304. It has passed the Senate. It's now in the Assembly. The governor has not yet signed it, but what it would do is it would specifically include in that law an exemption or it would include in one of the reasons that would qualify an employee to use the earned sick leave. It would add subsection C, which would say during a time during which the employee is not able to work because of, it would add during a state of emergency declared by the governor or upon recommendation, director, or order of a healthcare provider or the commissioner of health or other public official. So essentially, this is basically what we've already been telling all of our clients. If you offer paid sick leave, which you have to, the 40 hours under the Earned Sick Leave Act, we've been telling employers and our clients, let your employees use that leave for any period, any absence that's caused by the pandemic, okay? And we're talking in broad terms because basically our recommendation is that clients should be relaxing their attendance policies and should be basically letting their employees use whatever paid time they have available. But the next question always comes is, well, can we require that they exhaust it? And unfortunately, no, because the statute specifically states that NJSA 3411D2 subsection D, that an employee shall not be required to use accrued sick leave. So the bottom line is that most employees, the reality of the situation is most employees are going to want to use that time because they want to, they have to be able to pay their bills, so they're going to want to use that time. Our recommendation is make sure that it's clear that the time is at the employee's option. So how is unemployment insurance dealing with all of this? Well, if you go on to the New Jersey Department of Labor, the unemployment, they've actually created a whole coronavirus page that answers a ton of great questions and basically will help your employees figure out whether or not they can apply under due to coronavirus. There's also the BC-10 form, which all of you should already have, but if anybody needs it, feel free to reach out to us. We can give you a copy. Essentially, you're going to give this form to your employees. It's going to help them file claims for unemployment. There is an area on the form where you can check temporary, and you put on there the date of recall or the expected date of recall. And so what you can do is, and you can write on that form, due to coronavirus or something, and that will help the employee file their claim. Okay. So the last few things that I want to talk about with regard to furloughs and temporary layoffs is non-discriminatory considerations, okay? And that's going to be essentially just like any other reduction in force. Make sure that when you're trying to figure out who you're going to furlough, that you're not using someone's protected class. So it kind of, one client, and again, these are all benevolent reasons. We got a question of, well, we have a group of employees that are, can we just look at our employee census and furlough everyone over 55 because they're in a risk factor? Because they have risk factors, or we want to protect them. And my answer is be very, very careful about how you implement furloughs and temporary layoffs. Do not use any protected characteristic as any criteria for that layoff. And so what we recommend is that you focus on your group. If you are a manufacturer, if you have to close down a line, or if you're a restaurant and you've had to close the entire restaurant, well, then everyone's going to get laid off, or a certain percentage of your workforce. And so try to use legitimate criteria when you're selecting. And A3848, this is a new law that was signed by the governor over the weekend. It specifically prohibits employers from terminating any employee who is likely to have an infectious disease or that requires the employee to miss work. Essentially, if you have an employee who tests positive for COVID, or if you have an employee who has COVID symptoms and they're seeking a diagnosis, don't include them in your furlough or temporary layoff without speaking to us first. We want to make sure that you reduce your risk. And we would recommend, and I don't know how Matthew feels about this, but our feeling is that if you have someone who might qualify for leave, you may want to consider putting those employees on a leave of absence due to any of those protected reasons, and not automatically terminating those employees. Now, again, everything is going to be on a case-by-case basis. Everything is changing day by day. So we just want to make sure that these types of decisions are thoughtful and that there's good reasoning behind them. All right, so I think, Nick, do I have a couple minutes left, or how are we on time?
I think we're good there. I know Matthew, you just texted me that the DOL just issued something while we were on the
it's changing minute by minute.
So yeah, we're trying to be as current as possible. I know Cynthia is probably checking Twitter for updates on the stimulus package for her presentation. But Matthew, do you want to just jump in real quick?
We just wanted to let everybody know that the DOL has just published the notice poster that needs to go up. So we'll send out a link to that, but also you should be able to get that on their site. So that poster has now been sent out. So take a look. If you have any questions about posting it or anything else, contact us after the webinar.
Yeah, and I know that there were some questions in the chat. I figured it out why I wasn't seeing anything yet. I know that a lot of the questions that were directed, I think Emily did just cover. If there are specific things, again, please feel free to reach out to any of us here on the panel, and we'll coordinate and try to get you the specific responses that you need to the extent we didn't already address them.
And Nick, if I can take 30
Sure.
seconds, I do also want to just say that if you are a large employer with more than 100 employees, we need to discuss whether the Federal WARN Act or we call it the baby WARN in New Jersey. New York has a baby WARN. If you have more than 100 employees, if you're covered by the mini WARN, we need to discuss whether or not we need to work through WARN issues. And essentially, the issue is going to be, if you have more than 100 employees, if you fall under these statutes, you need to make sure that notice may be required. And again, this is all very fluid. The governor in California, he suspended the notice requirements for their mini WARN. Essentially, you would have to give 60 days notice of any kind of mass layoff or which would include an employment loss that would last longer than 6 months. And so with the time that I have left, if this applies to you, please call us so that we can try to work through this issue with you. We think that it's extremely likely that under the federal WARN, that the 60-day notice period would be relaxed because COVID is quote unquote an unforeseen situation. So New Jersey doesn't have exactly the same thing, but if it does last beyond 6 months, there is an exception under New Jersey's mini WARN if there's some kind of business circumstance that's not reasonably foreseeable. So again, if you have more than 100, if you think this might apply to you, reach out to any of us in the employment group so that we can try to work through the issue with you.
Awesome. Thank you so much, Emily. Cynthia. Cynthia is going to talk about the ever-changing, and obviously we had some developments up until this morning, so thank you for staying on top of everything that's been happening. She's going to talk about some of the state and federal regulations and address some HIPAA questions, which I know that I've been fielding left, right, and up and down. So I'll turn it over to Ms. Borelli.
Well, thank you, Nick. I'm going to talk about HIPAA very briefly, and I'll talk about it first. The audience should be aware that there are some very specific limitations on application of HIPAA where you have a public health investigation, and I think they certainly would apply here. So, for instance, if you're asked to provide information to a state agency or a federal agency regarding your employees' health conditions, and I think that could happen. There's an exception. You should do that because it's in furtherance of a public health exception. More on point, if you have questions about whether or not an employee who is either self-quarantined because they've been exposed or has been diagnosed or is showing symptoms, should you provide that person's name to other employees who are working around that person? I don't think HIPAA would preclude it here. I don't think HIPAA is going to apply in this context, and I think in the furtherance of the, the health of public health one and of your entire employee base, I think you have to do it. So we're sort of telling, that's what we're telling our clients to do that, and do it now, and we'll ask questions later. So let me move into the other federal action. President Trump called for big, bold, and immediate federal action, and in fact, that's exactly what he got. He's had 3 sort of tranches of relief. The first was fairly early in the pandemic, and it amounted to about $3.8 billion in economic relief. It was emergency services to get teams out there in place, EMS teams, equipment. So it amounts to 8.3 billion rather. The second bill is primarily what Matthew has talked about, which is it provided for paid sick leave. It also provided for paid virus testing, which some of the state departments of insurance have done in terms of requiring copay and co-insurance waivers for diagnosis and testing with regard to the coronavirus. It also, the second wave also provided for enhanced unemployment support, not in terms of extending unemployment, which was done this morning, in terms of providing resources so that, as Emily said, the state employment agencies have set up their own websites and they can get money out to people quickly who are already applying for unemployment. The third package was the Stimulus Act. It was adopted, well, it was made law this morning when both houses adopted it early in the morning. It's $2 trillion, and it offers a variety of relief both to individuals and to businesses alike. The first piece is $500 billion, which will be created to assist stressed businesses. $425 billion of that will go to the Federal Reserve to leverage loans to a broad array of large corporations. The remaining $75 billion is dedicated to industry-specific loans. Some of them are the hotel industry, the travel industry, the airlines. The third was access, and the third important thing to note is that access to the funds is being overseen by the Inspector General along with a 5-person committee appointed by Congress. Any business which seeks to access these funds has to make certain promises, to the government. They have to make efforts to maintain their employee count during the term of the pandemic. They also cannot, they have to halt stock buybacks for the duration of the government assistance plus an additional year period. There's also $130 billion being directed towards assisting hospitals. $150 billion is being directed towards state and local governments. $350 billion will be used to establish a lending program for small businesses, but again, only for those who keep their payroll steady throughout the crisis. The remainder of this morning's package is aimed at assisting individuals directly. So workers making less than $75,000 will receive a direct payment totaling $1,200, and the amount will be phased out as your income moves from $75,000 to $99,000. At $99,000, you get no subsidy. Families will receive an additional $500 per child, and while I have the actual bill in my inbox, I haven't read it yet. So although I assume I can't verify that the $500 is only available if you're an individual or family that would qualify for the relief, but I don't know that yet. Unemployment benefits are going to be extended by 13 weeks along with a 4-month enhancement of benefits. And I think the enhancement of benefits is that there is a goal to permit most workers to maintain close to their full salary during this time. Integral in the Democrats' efforts was a provision which would prohibit any business owned by President Trump and those of other senior government officials from receiving benefits from the stimulus package. I'm going to move on quickly to the state initiatives. New York is now the epicenter of the virus, and they have been extremely active on all levels. My focus is always DFS, the Department of Financial Services, which governs the banking and insurance industries. If you want to look at our website, you're going to see that I have an alert with pages of regulatory initiatives that DFS has implemented over the last week or so, really designed to not to force, but to ask the banking industry and the insurance industry to exercise reasonable prudence and to forbear with regard to mortgage, those who've taken out mortgages, loan holders, policy holders, in terms of, giving them flexibility in repayment of loans, repayment of mortgage, premium on policies, repayment of policy loans, trying to, waive periods, relax periods. None of this is really mandatory, at least not yet. Some of the other things that the states have done in New York and New Jersey, and New York is included, is a data call. They put a data call on March 10th, and the data was due, I believe, on the 18th of March, and it went out to the insurance industry to get information on business interruption coverage. And I think also there were some questions on travel coverage. One thing that New York did is they requested that policy forms be filed to allow for the sale of travel insurance with no exceptions. And I believe that there have been some forms on file. The data call was really explain your coverage, explain your exclusions, how do you interpret, and the information is collected. The presumption is that New York, like New Jersey, and New Jersey is the bill which I'm going to talk about, will ask that business interruption insurance be afforded to policyholders who have bought it without regard to certain exclusions in the policy, which is a unique approach. So far, to my knowledge, New York has done nothing more with that. New Jersey, however, has a bill was introduced into the Assembly last week. It's A3844. The bill was introduced and immediately went to committee, and it was quiet for the first week while the sponsors met with representatives of industry and their trade associations to negotiate some contribution by industry to the pandemic, a financial contribution. Otherwise, the bill would provide that for statutorily mandated coverage. Even so, only employers who purchased business interruption insurance and only employers that had less than 100 employees would be required to waive exclusions for virus, bacteria, which are now, especially since SARS, common exclusions in business interruption policies. I think the industry argued, one, that it's somewhat unprecedented to mandate coverage. It's different to ask for a moratorium on cancellation and non-renewal, which not yet has been asked for, although many states have asked for leniency. But to mandate coverage is a different story altogether. And so during the period of negotiation, the sponsors asked for ideas. I think yesterday they decided they didn't get sufficient ideas, and the speaker was asking Senate to move forward with the bill, and they were going to move it out of inactive status. As of last night, industry prevailed, and I think primarily through their trade associations, and the bill is now, the sponsor and the speaker are now waiting to see how the stimulus package, which in fact was introduced early this morning, how it unfolds to provide necessary protection to small businesses. Whether that bill will move or not, nobody can predict, but I do think that insurance regulators are very focused on providing support to small businesses in the community. Some of the other things that the various states have done is to call for disaster preparedness plans, both from insurance companies in some states, from the insurance producers. So they wanted to know, generally, were you prepared? What's your business continuity plan? Some asked for specific amendments to pre-existing filed plans to address COVID-19. How are you going to operate your business? How are you going to continue to provide the vital insurance services? How are you going to protect the policyholders? How are you going to expedite claim payments? Other things that have occurred is mandatory enhancement of telehealth and behavioral health medical services to broaden access. As I mentioned before, waiver of copays, allowing use of telehealth services from home, it encourages the social distancing. It maintains the virus from spreading, and it makes it easier for the insured community. New Jersey has encouraged forbearance on premium payments, on loan payments, extension of grace periods, waiver of late fees and penalties. They've, again, not mandated, but asked for forbearance on cancellation and non-renewal of policies. And I think they've all been important measures. I think the next days to come will move from suggestions and requests in many of the states to imposing mandatory action. One thing that the industry has done through the NAIC, the National Association of Insurance Commissioners, is ask that states act together consistently and coordinate their efforts so that the industry doesn't spend most of its time responding to these inquiries and data calls, when what they really should be doing is making sure that their processes are in place, that their claims are being paid, and that their policyholders are being protected. So with that, I am happy to entertain a couple of questions if I have time. If not, we'll move on to Evan.
Yeah, thank you very much, Cynthia. What I'm going to do, because we're getting a little bit crunched with time, is there have been a handful of questions. I'm gonna link our email addresses in the group chat. Additionally, Matthew posted the DOL notice poster in the group chat. I received a text from a couple of people who were asking me to send that to them. If you can't access that through the group chat, please just shoot any of us an email or text, or however you can get in touch with us, and we'll endeavor to get that over to you guys as soon as possible. Also wanted to let everybody know, I think I was supposed to mention, I'm not sure, next week we're going to be talking about cybersecurity in the age of COVID. Obviously, there's been a lot of scams and things like that, and we're going to address that next week. We're aiming to keep this regular Wednesdays at around 12:30, so stay tuned for that. Second or third, for the CLE people, the second code is going to be distancing, which I'll also throw in the group chat. So it's social and then distancing. Ty tried to be topical, and I was shot down on Tiger King, so we're going with social distancing. And with that, I'll turn it over to Evan Yablonsky, who's going to talk about some of the contractual provisions, some of the issues here, because we're obviously seeing at all levels of business that, there's not going to be non-performance issues, given the fact that a lot of businesses are simply not allowed to operate, and other ones are operating on reduced schedules. So Evan, I'll turn it over to you, because we're creeping up on an hour, and I'll shut off and let you just do your thing.
Thanks, Nick. I don't know how I'm going to follow up on Tiger King, but I'll do my best here. As Nick said, nearly every company in just about every industry has contracts that are going to be affected by this. And in all likelihood, your contracts, you're going to be on both sides of this issue. You're going to want to excuse performance because of what's happening with the pandemic around the world. And you're also going to be upset and try and stop other companies from excusing their performance on your contracts because of the pandemic. So what are we looking for in our contracts? And I think the first thing you want to look at is your force majeure provisions. And for those of you who don't know, we're essentially talking about a provision in a contract that excuses performance for specific events. And every contract's a little different, but typically you're talking about things like acts of God, terrorism, other unforeseen circumstances. And the idea here, again, that general purpose is to limit damages where the reasonable expectations of the parties and the performance of the contracts have been frustrated by these unforeseen circumstances. And that's the key. It's really, we're talking about these unforeseen circumstances, times when, just like now, to use a legal phrase, the world's gone a little crazy. And that's what these are for. There's not going to be a standard force majeure provision. Every provision is going to be written a little differently. Every jurisdiction is going to view them a little differently. But there are some events that we can look at that are built into various force majeure provisions that can come into play here. The first and most obvious one is if there's discussion of events such as epidemics, pandemics, disease-related events. Those are obviously and almost always going to be covered by a force majeure provision. If your contract has that exclusion built in as an event, then your performance is going to be excused. It's important to note, though, a lot of force majeure provisions contain the event of an act of God. Most jurisdictions won't consider a disease or a pandemic an act of God. Typically, acts of God are limited to things like natural disasters, earthquakes, tsunamis, hurricanes, things of that nature. So you just want to be careful that you're not relying on an act of God provision in most jurisdictions. You obviously need to check because all jurisdictions handle this a little differently. Another event that is in some force majeure provisions is government shutdowns or government regulations. We've seen that so many of our states, cities, municipalities, even some countries are being shut down for non-essential services, quarantines, shelter in place, you name it. That can be another avenue to excuse performance. And one of the times we saw this was in New York following the horrible events of September 11th. There were cases and contracts that required travel. New York was in a virtual lockdown for at least the next 72 hours following that morning's events. You couldn't get on a plane. You couldn't land a plane. You couldn't fly anywhere. And so there were cases where travel was an essential requirement of a contract. The force majeure provision included an event of government regulation and shutdown. And so that performance was excused. They were able to, because of the terms of the contract, not be liable for defaulting on the contract. But not all contracts are going to include things like epidemic or pandemic or government shutdown. What you want to look to then is your catch-all provisions. Most provisions will include phrases like any other events or any other events beyond the reasonable control of a party. And those are great, and you certainly want to look to them if you don't have anything else, but you need to understand that most jurisdictions view those very narrowly. Some, even such as New York, almost completely negate them, essentially saying that if you didn't specifically enumerate the event, it's not going to count. But even those jurisdictions that do look at your catch-all provisions more broadly are almost universally going to require a foreseeability. In other words, if you could have foreseen this coming, you should have specifically enumerated it. It's only if the event was not foreseeable that your performance will be excused under a catch-all provision, which then obviously begs the question, is COVID-19, is this coronavirus that we're dealing with foreseeable? And I think that is going to be, quite frankly, the subject of huge litigation coming forward. If you're trying to excuse performance and say this wasn't foreseeable, you're probably going to look at what the comments of lots of world leaders, the World Health Organization, about how unprecedented this was, how this could never have been, believed to have happened. If, on the other hand, you're trying to say that this was a foreseeable event, that you can't excuse performance using a catch-all provision, you're going to look at things like the SARS epidemic of 2005. You're going to say, we knew this was coming, some type of event like this. We may not have known the magnitude of it, but we knew this type of event could occur, and therefore it's foreseeable. You can't excuse performance. It should have been specifically enumerated. The other thing you're going to want to look at is the timing of your contract. If this is a relatively new contract and you drafted it and signed it in late January, early February, well, that's going to hurt your foreseeability argument. We already knew that there was an outbreak of the coronavirus. We already knew cities were being quarantined. So that's going to change the analysis. It's pretty fact specific. Nick, I can't help but notice that I'm running out of time, and I know that most people are going to run off and be done with their lunch hour now. I don't know if you want a couple closing words or you want me to keep going.
No, what I would just say, I think that we can cover this offline if people have specific questions. But as far as entering into new contracts, now the business world is going to continue. There will be new deals being entered into, whether it's business as usual or contingency or just planning, given the new landscape that we're dealing with. Can you just give everybody some practical tips that you would think that they could include to the extent they're going to enter into a new transaction at this time?
Absolutely. I know it feels like the world is ending, but as we all know, our businesses are continuing and everybody is still trying to do their job. I think when you are drafting new contracts, you absolutely want to plan for the effects of COVID-19. How do you want performance to be excused? Is it upon a quarantine, or do you just want performance to be delayed based on that quarantine or the shelter in place? How do you want to handle the interruption of business? I think these are all the questions you have to be looking at when you're drafting new contracts, and making sure that you've thought through the ramifications.
Great. Thank you, Evan. And with that, we are hitting a clean hour, 1 minute over, but I think we started 1 minute late. So we appreciate everybody for tuning in today. We had over 200 people. I know a handful from inside Bristol, a lot from outside. We appreciate everybody watching and listening and tuning in. And like I said, we're going to try to make this a weekly webinar with different areas of law being featured. Obviously, we felt like these were the most pressing issues that everybody's dealing with right now. And next week, we're going to talk about some cyber issues that are coming. And then from there, we have a handful of different ideas. But we love seeing everybody. Hopefully, everybody loves seeing us. And we're going to try to do this more regularly. So everybody stay safe. And thank you for tuning in. If you have any questions, please feel free to reach out to anybody on the panel, and we can direct you in the right area. Our emails are linked in the group chat. The DOL posters linked in the group chat. All you have to do is click on any of those things, and you should get that information. Stay tuned, and we'll talk to everyone soon. Thank you.
Thanks, everybody.